Assalamualaikum warahmatullahi wabarakatuh. My name is NurulMahfuzah Binti Masmi Tajuddin. My match number is 1201614. So today I would like to present case review from the case of Nadia Binti Muhammad Arifin against Khairul, Nizam and Rozali. This case is regarding to the maintenance of the children. Firstly, based on the fact of the case, it is stated that the case began when plaintiff filed a case for a claim of maintenance of children in the Sharia Lower Court of Seremban on 26 of August 2015, which fall under Section 74 of Islamic Family Law Negeri Sembilan Enactment 2003. The defendant and the plaintiff were married on 25th of February 2006 at Negeri Sembilan, and throughout the marriage, which was about 9 years, they were blessed with 3 daughters with age of 12, 9 and 5 years old. Later, both of them were divorced on 9th of April 2015 by way of talak redemption in the Sharia Lower Court of Seremban. It is stated that the summon and statement claim were completed to the defendant by hand delivery on 28th of September 2015, and it is recognized as completed by the court because it fulfilled the requirement of Section 41 Clause 1 of the Sharia Court Civil Procedure Enactment Negeri Sembilan 2003. The court then approved the plaintiff's claim and ordered the defendant to bear the maintenance of 3 children, which amounts of 2,590 ringgit per month. Next, the parties involved in this case, including of the plaintiff, which known as Nadia Binti Muhammad Arifin, and she is a doctor. Throughout the trial, the plaintiff were represented by Datuk Hanif bin Hassan and Puan Sumayah binti Jamil, which are Syar'i lawyers from Mers Hanif Hassan and Co. Meanwhile, the defendant known as Khairul Nizam bin Rozali, and he worked in medical field and has a salary of 14,227 ringgit. The defendant then was represented by Encik Abdul Razak bin Muhyiddin, which is a Syar'i lawyer from Mr. Abdul Razak Muhyiddin and Associates. Next, there are 3 issues arise in this case, which are: the first one, whether the Sharia court has jurisdiction to hear, discuss and decide claim of maintenance of children by the plaintiff. Number 2, whether the plaintiff is qualified to claim maintenance of children against the defendant. And the last one, the issue is regarding the amounts of maintenance of children are entitled to receive. Now, let's move to the argument by the parties. The plaintiff argued that the monthly maintenance paid to the children, which is Rm 900 per month since 2015, was insufficient and need to be increased to Rm 7,750 ringgit in 2017. It is because the children were grown up as well as the child's needs were increasing. Meanwhile, the defendant contended that he had fulfilled his responsibility to allocate monthly maintenance to the children as much as 900 per month without being asked by the plaintiff, starting from the plaintiff and the defendant divorce until now. After that, based on the judgment given by the court held that the Sharia court has the jurisdiction to hear, discuss and decide the children's maintenance claim by the plaintiff. Next, the court also approved the plaintiff claim, which is regarding to maintenance of children, which fall under Section 74 of Islamic Family Law Negeri Sembilan Enactment 2003. The court also ordered the defendant to bear the maintenance of 3 children, in which amounting to Rm 2,590 ringgit per month, including of food and drink allowance, house rent, transportation, housekeeper, initial expenses of children's schooling, preparation expenses for Hari Raya Aidil Fitri of children, annual leave expenses in the country for the children, and the last one, the court dismissed the plaintiff claim for insurance, for hospital, education, as well as for the tuition fees. Lastly, for the commentary section, I do agree with the judgment given by the judge regarding to the maintenance of children, where the defendant was ordered to pay the maintenance of 3 children with a reasonable amount after taking into consideration the amounts of maintenance necessary for the child's upbringing and living, also without causing hardship to the person whom the order is made, which is the defendant itself. So this is in accordance with the Section 62 of the Islamic Family Law Enactment Negeri Sembilan 2003. Next, I would like to suggest to both parties to settle their dispute during the suluh process from the very beginning, so that the mutual agreement regarding to the maintenance of the children can be decided quickly and will not take quite a long time to be resolved as in the litigation process. So I think that's all from me. Thank you.